District Court of Appeal. We have one case on the docket today, James Stewart Price versus the State of Florida. Counsel for Appellant, if you're ready, you may proceed.
May it please the Court, my name is Emmeline Dalton and I'm with the Public Defender's Office. I represent the appellant, James Price, in this direct appeal of his conviction after a jury trial. Unless the Court would prefer otherwise, I would like to rely on the briefs for the first two issues and focus my time today on the third issue. I would also like to reserve 5 minutes for rebuttal.
Okay, so noted.
The trial court committed prejudicial error when it gave the voluntary intoxication instruction in this case. The voluntary intoxication instruction is to be given when applicable, and it is applicable when the defense raises evidence that could be considered as negating intent based on voluntary intoxication. That did not happen here. Mr. Price did not introduce any evidence of his intoxication. Any evidence of intoxication was introduced by the state, and whatever purpose that might have been, it was definitely not to negate intent, which is an element of the crime they were trying to prove beyond a reasonable doubt. The voluntary intoxication instruction is located in Chapter 3, the final charge to the jury, which includes defenses, affirmative defenses to be raised by the defendant. Specifically, in the comment to the standard jury instruction 3.6b, which is for insanity and hallucinations, the comment to that standard jury instruction says that if voluntary intoxication is raised by the defense, then the court should refer to 3.6d, which is the voluntary intoxication instruction.
Is there any authority that would support an argument that a trial court may not give that instruction unless it is raised as an affirmative defense?
Yes, Your Honor. So the only authority that exists on this specific issue appears to be when the defendant raises the defense of voluntary intoxication, either in effect, so by negating intent, by showing voluntary intoxication, or actually raising it. There's not any specific case law that shows that if there's some evidence of voluntary intoxication but not introduced by the defense, what should happen at that point.
Okay. And you're not arguing that there was a lack of evidence of intoxication, correct?
No, Your Honor. I am saying that any evidence of voluntary intoxication was introduced by the state, not to negate intent.
And you also don't argue that the jury instruction was not a correct statement of the law?
Correct. It is a correct statement of the law. It's just not relevant to the case, and therefore should not have been given.
But let me state it differently. So the jury instruction was a correct statement of the law, and it was supported by the facts entered into evidence, correct?
Yes.
All right, so on that, with that, how could it be a reversible error for the trial court to instruct the jury? What authority supports reversal when a trial court correctly states the law and the evidence in the record supports that instruction?
So I would clarify that I don't believe the evidence in the record supported giving the instruction. I believe that there was evidence of intoxication, but I don't believe that it went to the element of intent or in any way to negate that element. So I don't think that the evidence supported the giving of the instruction, in that the evidence of voluntary intoxication was not introduced in a way that would require this clarification on the part of the judge.
Okay, I'm not sure I understand your argument. So let's start at a more basic level. There was evidence of involuntary intoxication.
There was evidence of voluntary intoxication introduced by the state to show, to prove the offense occurred.
All right, so you're just arguing really more a legal argument that that instruction can only be given when advanced by the defense.
Yes, so my argument would be that the purpose of the instruction is to clarify to the jury, if the defendant tries to argue that his voluntary intoxication negated the element of intent, the instruction exists to make sure the jury knows that there is Florida law that says that voluntary intoxication is not a defense to any crime in Florida, and it cannot negate intent.
Is it your position that the state could not request that instruction?
Yes, I think that that is my position, because if that were the case, then they could, it's a penalty against the defendant when it's a trial strategy of the defendant not to raise their intoxication. They don't want to bring it up. They're not trying to argue that they didn't intend the crime in that way or because of that voluntary intoxication. And so by giving this instruction after the state, hammers in the fact that they believe the defendant was intoxicated, I think that it improperly encroaches on the job or the function of the jury to determine whether intent existed.
So you believe that there was a penalty or harm to the defendant here, even given what the circumstance and the facts were here, being that this arose in a bar with a broken beer bottle, and that there's still a harm or a penalty associated with it?
I do, Your Honor. I believe that, the situation was that the jury asked a question about what does intent mean, a general question about that word and the definition of it. The judge gave a response based on conversations with both counsels, and then came back afterwards, after almost 2 hours had passed since the jury's originally retired to deliberate, and said, I'm worried that the jury might be thinking that because he was possibly intoxicated, there couldn't be intent. So this was, first of all, an impermissible kind of detour into what the jury might be thinking. It also, then by giving the voluntary intoxication instruction after this question about intent, he was sort of giving, his opinion or showing a bias towards the state's position in the case.
It seems that your argument, though, creates kind of a trap for the state. If the defense decides not to raise that affirmative defense of voluntary intoxication, the jury could be misled into thinking that the fact that the defendant is intoxicated would not allow the defendant to form the necessary intent to commit the crime. And since your position is also that the state couldn't ask for that instruction, it seems that it's kind of a win-win for the defense. If the defense doesn't, it prevails, because the jury thinks that there needs to be intent for someone who is voluntarily intoxicated, there's an acquittal. And then if there isn't, then, you might have an issue on appeal.
Yes, Your Honor, I understand that concern. My response to that would be that the state, in this case as an example, used the voluntarily intoxicated state to support their offense, to support that the offense happened, to show that he was belligerent, he was in a state of mind that would have, supported or led to the alleged actions. So I don't think that it can be a hindrance if they're using it as something to progress their case. And then my second response, or my second half of my response to that would be that this instruction is supposed to be used as, a clarification on an affirmative defense. And it is the defendant's decision whether or not to raise an affirmative defense. The trial court, therefore, based on all of this, I would say the trial court committed prejudicial error when it gave the voluntary intoxication instruction, as this interfered with the jury's determination of specific intent, amounted to an improper comment on the evidence, and caused the court to abandon its role as neutral arbiter. The standard of review here is abuse of discretion, which in Perry v. State, which is used in both briefs, 56 Southern 3rd. There's three kind of prongs to the abuse of discretion standard. And that starts with, did the court accurately state the applicable law? And I do agree that this was the standard jury instruction. That's not something that we're arguing. But the second two prongs, did the facts support giving the instruction? And this goes back to your question, Your Honor, that although there was evidence that suggested that he may be voluntarily intoxicated, it did not reference in any way, shape, or form the element of intent, which is what the jury instruction is created to remedy, if it did. And then third, the instruction was necessary in order to allow the jury to properly resolve all issues in the case. It was not necessary because the defendant was not arguing that he did not intend the crime based on any voluntary intoxication. So by giving the instruction, all the judge could do is offer confusion for the jury.
I'd like to go to issue 1, which was the excited utterance argument, and I just want to clarify a statement in your brief on page 14. Your assertion in the brief is at the time that the witness, Ms. Beamer, placed the call, the startling event had ended. I listened to that call a couple times again this morning, and it appeared that that event was occurring. It may have ended at some point during the call. Do you want to clarify your statement in the brief?
Yes, Your Honor. I would just clarify that I believe Ms. Beamer's involvement in the startling event had ended. The threat was removed from her, and any possible threat was removed from her, and he was almost out the door at the time that she made the call, so I don't believe that she was still involved in the startling event.
Okay. Thank you, counsel.
Counsel, had the state requested this jury instruction during conference, would the trial court have erred in giving the instruction?
I'm sorry, Your Honor, can you
Had the
repeat?
state requested this instruction on voluntary intoxication during the conference, counsel, would the trial court have erred in that case in giving the voluntary intoxication instruction?
Yes, Your Honor, I believe so, my position is that this instruction is meant to clarify that there is no affirmative defense for voluntary intoxication, and as that affirmative defense was not raised, it would be error to give an instruction on it. Thank you. I would like to reserve any remaining time for rebuttal.
Thank you, counsel.
May it please the court. My name is David Welch. I'm with the Attorney General's office, and I represent the state of Florida in this case. I'll start with the third issue, too, since that seems to be the main point of the argument. It's the state's position that the voluntary intoxication instruction should have probably been given as part of just the normal jury instructions, as intoxication obviously played a large role in this trial. And it's black letter law in Florida that you cannot raise voluntary intoxication as a defense. So when the appellant talks about how, well, this instruction was improperly given because they never raised a defense that they're not allowed to raise, that just doesn't follow that for this instruction to be necessary, you have to raise the defense that you're not allowed to raise. It doesn't follow. It should have been given. And the rules of criminal procedure allow the judge to recall jurors for additional instructions after notice to both parties. And then the Florida Supreme Court back in Griffin v. State in 1982 specifically stated this authority encompasses the giving of additional instructions that were inadvertently omitted. And that's the state's position in this case, that the voluntary intoxication instruction should have been given. And I believe what happened in this case is, as the jury was deliberating, they asked the question. They said the group wants the court's definition of intention. The court originally told them to rely on their recollection and to rely on the instructions. My guess, and again, it's only a guess, is that the judge in this case went back, reread the instructions, realized that this instruction had inadvertently been omitted by both the court and the state and defense, recalled the jurors to properly instruct them on the state of Florida law to make sure that they could make a verdict in line with the law. And the state's position is the judge does not depart from being a neutral arbitrator by telling the jury what the state of the law is in Florida.
Well, and you referenced the case, Griffin, on this case, talking about an inadvertent omission of the jury instruction. Was the state's failure to request this instruction inadvertent?
I believe so. Again, I don't know what the prosecutor's mind was, but in a case where you have an individual who is, in all evidence points to be involuntarily intoxicated, the state should request this instruction just to clarify for the jury that, by the way, that doesn't negate his intent in the state of Florida. And then turning to the first issue in terms of the excited utterance, you mentioned that you listened to the call. I believe when you listen to the call, it's obvious that the appellant was still inside the bar when the call was made. At some point during that call, he exited the bar. He was out, and it sounds like he was in the immediate vicinity. And again, one of the issues on Excited Audience was the statement made before there was time to contrive or misrepresent. Even if the event had just ended or ended as the call was ongoing, again, there's no time for the caller to misrepresent or contrive a story. It was basically a stream of consciousness to the 911 operator who was requesting information because the police hadn't even arrived when the call was being made. And I think if you listen to the call, you'll see that it actually ends as the police are arriving to arrest the appellant. And then, besides excited utterance, it potentially could fall under as a spontaneous statement because it's describing or explaining an event made while the caller was either perceiving or immediately after perceived an event. So in this case, the state's position is the event was ongoing. There was, you still had a intoxicated individual who had displayed violent behavior, who was roaming around. That's an ongoing event. It's an ongoing emergency until the police can arrive and take control of the situation. So, our position is the caller it was a startling event. The caller had just witnessed it, had made the call while the appellant was still in the bar, and then finished the call once the police arrived to arrest him. And if there are no questions, for all the reasons stated in the brief and today, the state asks that this verdict be upheld.
I do have one question.
Yes, Your
If we were to agree with the appellant on issue 3 that the court did commit reversible error or error in this case, would you concede that that error was harmful if there was an error in giving that instruction?
I don't believe so. I wouldn't concede it because, again, all the judge did was tell the jury what the Florida statute says. Basically, if you look at the instruction, you look at the statute, they basically mirror each other.
And I understand you're arguing that act was not an error, but again, if the court did commit error by giving that instruction without the state requesting it, without the defendant requesting it, at a time that the jury was deliberating over intent, if we were to find that was an error, is it harmful or harmless?
The state's position would be harmless error.
Okay, can you explain why, based on the evidence in this case?
Well, the evidence in this case, I believe, is fairly overwhelming against the appellant. If you look at his jail call, he basically admits that he was intoxicated, he was upset, and he threatened someone. Well, he was, I forget his exact words from the jail. He admits to slamming the beer bottle on the table, and he admits it broke, and he said he worked, and that he was said a few cuss words. He's basically admitting to the crime. I mean, he doesn't exactly specifically state that he threatened someone, but then when you look at that in conjunction with the other evidence, specifically the 911 call, that he was threatening with a broken beer bottle, I think the evidence shows he committed the crime he was accused of.
Thank you, counsel.
Thank you.
If I could just briefly respond to some points made by opposing counsel. First, I wanted to address the case Griffin v. State brought up by Your Honor. And there are some distinguishable facts in this case from our case or the case at hand. Specifically in Griffin v. State, that involved a felony murder charge, and the instruction that was omitted was the instruction on the underlying offense. And giving the instruction on the underlying offense in a felony murder case is mandatory. Giving the voluntary intoxication instruction is never mandatory. I would also respond to the issue of, voluntary intoxication is not a defense in Florida. So why would there be an instruction if you aren't supposed to raise that defense? Voluntary intoxication can be used by the defendant to prove other points, to prove other issues, and at that point, if the defendant were to raise the issue of his intoxication, and it could in any way, shape, or form make the jury think that its purpose is to negate the element of intent, that's when the voluntary intoxication instruction would become necessary or proper. That's when it would be applicable. Thank you for your time. If there's no further questions, that concludes.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.